Hi all, my name's Tom and this is an update on the court cases we've been going to just recently, and I do apologise to all those that's been following us. We couldn't put out all the information. We're having to cover our tracks because of agents and also quite nasty individuals that's trying to disrupt court cases and also give out misinformation to the general public, try to blacken our names. Now, for all those that haven't seen our videos, go to our, or don't know our story, go to our YouTube channel, watch video 1, and then the following ones I'll give you a good insight exactly what's been happening up to date. But to tell you what happened on the 2nd of July, approximately 200 police, 21 riot vans turned up, 3 armed response units, dog teams, 40 to 50 bailiffs, helicopters, an ambulance, and also the fire station informs us that a vehicle was put on standby in case it was needed. Any right-minded person would think, wow, they must be extremely dangerous, these people. Well, it's just myself, a wife and my daughter, and they were coming to take a 2-bedroom house. And yes, we are extremely dangerous. We are extremely dangerous to the banks and to the courts. We've been giving out information to the general public that was meant to be kept very secret, especially the court information. In fact, it's so affected them that they've had to change their motive operandum. They've been, that's the way they do business. You normally go and you try and get your documents or file documents. You can't do this in London now. They're shutting down all the county courts and you put it in a letterbox because they don't want even to get their Mickey Mouse stamp off them, which is a really false stamp. It's not a real seal. Now, take you more up to date with the 3rd of September, when we were in court, we placed in front of a judge who was a substitute judge. Our judge was removed deliberately and a gatekeeper judge was put in his position. This judge went immediately on the attack of myself regarding third parties, and then we found out that that was his speciality. I'll tell you more about that in a moment. Now, I placed before the judge information. I said, you cannot rule in this case and kick it out because it doesn't have merit, because I'm putting facts, not hearsay evidence. I know they allow an amount of hearsay, but when facts are presented, it overrides their hearsay. Number one fact, the bank, Bradford and Bingley, never paid a fee into the court to start the whole procedure. Now this, please remember, this is very, very important. They never paid a fee to start proceedings against my wife and myself. Number 2, they never produced any accounts to prove that we've got any debt owed for them to come and take our property. Well, even if we did have debts, they're not allowed to take the property. They're allowed to sell it, but you'd be a sitting tenant. But the other thing is, they can only take mortgagee's property if there are arrears, and this was confirmed in every court case that there wasn't any arrears apart from the first one in 2012, where I got, my wife, 3 payments behind, and we cleared that before the next court case, so there was no arrears, so they couldn't have taken the property. But that aside, we didn't go down that route at all. We went down the evidence, no fees, no accounts. If we were in debt to anything, it was their duty to present it in front of the court. This they failed to do, and this they continue with the assistance of the court to avoid. Now we've got a letter from the county court in Nottingham stating that they have no evidence that a fee has been paid. Neither the court nor the bank have produced an evidence, any evidence that a fee has been paid. Now it's very important that, and I'll tell you for why. I'll put my glasses on for this. Practice Directions 55.5 in brackets 1. No step may be taken until a fee has been paid. I stated this to the judge, and the judge said it's his court and he would allow it anyway. And I'll tell you why he is allowed to allow it. And then under CPR rules 3.7, the court will serve a notice on the claimant requiring payment of the specific fee in relation to the fee order. The claim, and down at I in brackets, the claim will automatically be struck out without further notice if a fee has not been paid. There is the directives for them to pay a fee. They didn't pay a fee. It was the simplest thing in the world for them to turn around and present a payment for a fee. In fact, I gave them a document to sign under their own personal liabilities. The barrister representing Bradford and Bingley, and he refused, and the judge said I can't make him sign it. Because he knew, I knew, and the barrister knew that there's never been a fee paid. It should have been kicked out then. I asked them to produce the accounts. They refused again. So we produced the facts. They went on hearsay, and lo and behold, the judge, Judge Phillips, said our case had no merit. And in his face, he looked embarrassed to be uttering these words, and he should be embarrassed. And then Bradford and Bingley solicitors proceeded to put a restraining order against me, piggybacking my claim with an N2444. Now, this was only a draft application, it wasn't sealed, and it was to have a restraining order put on me so I could put no more claims into court in case I upset them. Very, very unfortunate. They tried to tie me to a point where I no longer can get into court to attack them. But they failed in this because the judge aided and abetted a criminal offence in that court in allowing Bradford and Bingley to put a draft order into court on an unsealed document and not allowing me the minimum of 14 days to put in a defence. You're allowed to defend yourself in any case. And if I'd applied, I could have got 28 days like they did. So, in the future, they intend to use this, but we've put documents in to stop that. Now, we go on to the next case. I've been in court, and we've got another claiming a claim that they didn't put a defence into that court case I was just talking about. This is very, very important, and I'll tell you why. That's the document. I've covered up the actual date and time for it because of unscrupulous people that are willing to lie and cheat you, the public. Everything I say is documented. That was a claim that I put in, which is that's a notice of issue for a claim form, Part 8. When I came before the judge, he agreed. He said there was a case here, and if it had been money, he would have simply stamped the order and it would have been done. This is an administration. It's not a proper court hearing. So it will be going into administration very soon. Now, I'll show you the evidence. This is an acknowledgement of service from Walker Morris, which I consider a criminal entity representing Bradford and Bingley PLC. That shouldn't even be trading because they're a defunct company. There's more crime going on than meets the eye, I'm afraid. Now, down at the bottom, tick the appropriate box. 1. I intend to defend all of this claim. They ticked it. On the right hand side of that claim, of that acknowledgement, if you file an acknowledgement of service but do not file a defence within 28 days, they actually got 28 days, they were only supposed to have a very short time, which stretched to 14, but 28, judgment may be entered against you. Okay. So now you know it may go against them if they didn't do it. So here we go. Service has been filed. Okay, this is coming from them, and it says the defendant filed an acknowledgement of. It actually came from the court. The defendant has filed an acknowledgement of service on the 26th of August. Remember that date, 26th. The defendants responded to the claim indicating an intention to defend all of the claim. So we put our claim in, they are going to defend all of it. The defendant has 28 days from the date of service of the particulars of the claim to file a defence. So they're going to defend it. The only problem is, a long time after all that, on the 13th of October, I filed this in the court, plus all those other documents, and I checked with the court over the coming of the previous weeks, has the defendants filed a claim, and each time they told me no. So this was the last one. It said, "Dear sir, thank you for your email. No defence has been filed." Court stamp. Into the court. Off we go. We are now in front of a judge. This isn't for a proper hearing or a trial. This is simply administration. Did you file a defence? No. Then you've lost. And the reason why they've lost is the meaning of a default judgment, 12.1. Okay? In these rules, default judgment means a judgment without a trial where the defendant has failed to file a defence. A default judgment means you've won. That's it. End of matter. They can't appeal. They can't put the defence in now. They've had plenty of time. In fact, they've dishonoured the court as well. Conditions to be satisfied, down the bottom there, quite clearly states where an acknowledgement of service has been filed but the defendant has not filed a defence. Plain and simple. So, Judge Phillips, you allowed them to do this. You also allowed them to put an unlawful restraining order on me. Now, you the people, you look at this evidence, you've seen it. If I can, I'll put these documents up at the end of this video. I'm not an expert in this, but I'll try. You look at the evidence, look it up on the internet, you'll see that I am perfectly correct. It's been in front of solicitors and barristers, and the first thing out of their mouths was, "Congratulations. We should win this now." But they are criminals. If you remember in one of my videos I said, if they come and take this house, they will do it totally unlawfully. And that they did. and believe you me, I will have them in the criminal court because it's already started. And not for me, for them. Now, to take you up to date with certain things, people ask me, why did you not take crowdfunding? Well, myself and my wife have discussed it for about 30 seconds and then said, we are not prepared to give any money to blackmailers, these thugs and criminals in the banks and the courts. We will not submit to their bullying. We could have taken the crowdfunding, we could have got money other ways, and we would have still been in our little home and protected. But giving in to them, it goes against the grain. We will not be bullied. We have principles. We will not, people in the court, there are people out here that with principles. Judges, take note. There are real, honest people out here that will not be bullied and will not be blackmailed. Myself and my wife will stand up against you. Even if you find some sort of crazy rule, if you try and use a restraining order to go retrospectively back in time, which you're not allowed to do, which is totally unlawful, the case that's going on just now is still going on. Whether the order's gone through for the restraining order, you can't go back in time. It's not possible unless you're Doctor Who. Now, so that's why we will not take crowdfunding. And those criminals that's put it forward are there to profit by us doing it. Now, there's an auction coming off of our house on the 3rd of November, and that's in Nottingham, and the name of the Graham Penny is the name, I'm being prompted here, is the name of the auction house in Collet in Nottingham. So if you want to go along and see a crime in progress, I'm sure they'll be really pleased to see you, because they do like doing things in the open. They put them on television all the time to make it seem normal to sell repossessed homes, and it's not normal. It's an abomination to any right-minded man or woman. We're all in this together, and I'm not just doing this for our little family. As much as we need a home, we're still homeless. We're doing it for every one of you. We're doing it for the children, our grandchildren. They can't do this and continue to do it. So I think I've covered most things. I don't think there's anything else that I've got to say. But our next little video going up will be dealing in more depth with the actual system and how not to fall into their traps. And that's why there are people out there misleading you. Do not believe them. They don't send hundreds of police, helicopters to someone that hasn't having an effect on them. They're doing it because they're scared, and they're scared of you finding out. So, thank you for my little video, listening to it. So, go to the YouTube channel if you've never heard of us before. And Tom and Sue, that's us. Thank you very much for all your support, and keep up the good fight with us. Bye bye.